Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 153C assessments. In section 153C assessments, the assessment of 6 years is done for those assessees whose incriminating material is found in the search of other assessees. But the pertinent question arises that which 6 years to be taken for the assessment. The rule is that when the assessing officer of the searched assessee handovers the incriminating material to the assessing officer of the other assessee, then from that date the block period of 6 years is to be computed. For example, in this case, the satisfaction note was prepared on 2nd February 2016, but the date of handing over of the material was not available. Assuming that 2nd February 2016 is the date of handing over of the material, then in that circumstances, the year of the search is 15-16 financial year, and prior to that, the 6 years will be financial year 14-15 and 5 years back. Or in simple words, the assessing officer will be having the power to do the assessment for assessment year 15-16 up to the assessment year 10-11. But in the present case, the assessment in question in this year was of assessment year 8-9. The assessee was contesting that since the date of handing over of the material is not available in the records, so the date of the satisfaction note should be the date of handing over of the material. This issue has been taken by Delhi ITAT B bench in the case of Assistant Commissioner of Income Tax versus ENPRO Telecom Private Limited, and this case has been reported in 111 ITR Tribunal at page number 400. The date of the judgment is 8th February 2024. There was no dispute in the facts that in the satisfaction note the date of handing over of the material by the assessing officer of the searched assessee to the assessing officer of the assessee was not available. The assessee was contesting that the date of the satisfaction note should be considered as the date of the handing over of the material, and since the date of the satisfaction note is 2nd February 2016, so accordingly this date should be considered as the date of handing over of the material. So the assessment of assessment year 8-9 is time barred. When the tribunal heard the matter, the tribunal was of the opinion that in the present case, since there is no date mentioned of the handing over of the material, so the date of the satisfaction note should be considered the date of handing over of the material by the assessing officer of the searched assessee to the handing over of the other assessee. So the tribunal said that since the assessment is time barred, so the tribunal is not discussing on the merit of the matter. In the present case, there was another assessment year 13-14, for which in the assessment order there was no mention of any incriminating material. But during the assessment proceedings, whatever the documents have been submitted by the assessee to the assessing officer, from those documents itself the assessing officer prepared a show cause notice to the assessee and made the additions on the basis of that show cause notice. In the nutshell, the additions were not based on any incriminating material which was found in the search, but it was based on the material which was given by the assessee during the assessment proceedings. So the tribunal, by relying on the judgment of principal CIT versus Judicial Buildwell Private Limited, which has been decided by the Honorable Supreme Court in 2023 and which has been reported in 454 ITR at page number 212, in which it was held by the Supreme Court that in case of searches, the additions can be made only on the basis of the incriminating material. So in the present case, the assessment of the assessment year 8-9 was time barred, and the assessment of the assessment year 13-14 was not based on the incriminating material, so both the assessments were quashed. Friends, this case is very important and the name of the case is Assistant Commissioner of Income Tax versus ENPRO, Telecom Private Limited, and this case has been reported in 111 ITR Tribunal at page number 400, and the date of the judgment is 8th February 2024. Thank you, friends.